Welcome to UCounsel. This is our second lecture on the topic that if you are in a situation where you intend to claim refund of monies paid for a summer camp for your children or for airline tickets for the flights that have been canceled due to COVID-19, how do you go about doing that? Once again, we begin with our usual disclaimer that this lecture is not legal advice. So if you have any specific questions regarding your own issues, you should contact a lawyer or a paralegal or the Law Society of Ontario if you're in Ontario, or another provincial or territorial law society in a different province or territory. Now, in this lecture series, as I mentioned earlier, we have 5 lectures. And in lecture 1, we had already discussed the underlying legal principles that relate to breach of contract. In this lecture, we'll talk about some of the defenses to the breach of contract. So in the first lecture, we had talked about that if you are the party who is the non-breaching party, you are the party who is willing to perform the contract, but the other party has breached the contract, you are entitled to damages. Those damages could be more than the money that you have deposited or the value of the contract. It could be more than that. And then we raised the question that can the breaching party, the non-performing party, can it avoid liability? Can it avoid payment of damages partly or completely? And that brings us, and the answer was yes, and that brings us to today's lecture, which is the defenses to the breach of contract. In third lecture, we'll apply all these principles to a summer camp scenario. Fourth lecture, we'll talk about how to reverse credit card payments. And if all fails, then how do you go to court and claim your damages? Now, there are 3 kinds of defenses that a breaching party, a non-performing party, can claim. The first category is called common law defenses. So they come from the common law system, which is based on judge-made law over centuries. The second one is contractual defenses. So these are the defenses that could be found in a specific contract between you and the other party. And the third kind of defenses are statutory defenses, which may be codified in a statute in your province or in Canada generally. And so those are the 3 kind of defenses that could allow a breaching party, a non-performing party, to avoid some or all of the liability. So what are common law defenses? Let's talk about it. There are many justifications, many defenses for a breaching party to avoid liability or its obligations. There could be mistake, could be duress, coercion, could be misrepresentation. So there are all variety of defenses that may be available to a party. But with respect to the scenario that we are dealing with, which is COVID-19 and the pandemic, generally speaking, the common law defenses that would be applied to this situation would be frustration of contract, impossibility, impracticability, etc. So these are sort of the 3 kind. There is another one in the US called frustration of purpose. They're all kind of similar, not exactly the same. They have separate definitions. We're not going to get into that. We will try to keep it simple. So what you want to understand is that all of these defenses, what they are saying is that an event or occurrence have transpired, which is beyond the control of the non-performing party. So that event or occurrence has disabled the party to perform its obligations under the contract beyond their control. So, for example, there are a number of examples in the history that may apply. So it could be war, it could be serious crime, could be riots, could be strikes, could be natural disasters. All of these things may, depending upon the circumstances of the case, fall under frustration of contract, impossibility, impracticability. So in our scenario, the airline obviously is going to advance the argument that the contract is frustrated or impossible to perform because the governments have disallowed the international travels, and so they are ready to fly their planes, but they cannot because of the changes in law and regulations. And similarly, the camp providers will argue that their contracts have been frustrated because the government has closed the schools until September, at least in Ontario, and social gatherings are not allowed, which is why this is beyond their control and they're not able to perform the contract. And therefore, they should be excused from performing their obligations and, to some extent, liability. Now, what are the consequences of these defenses? When a court finds that the contract is indeed frustrated, it relieves both parties, of their obligations and liabilities. Now, what does that mean if the monies have been paid already? If there are any advance payments made, those need to be refunded, returned. Deposits need to be returned. And then if there are any deductions for expenses that may be possible, essentially the court is trying to sort of find how the contract can end in the best possible way without being unjust to any of the parties, right? So there are potentially some deduction of expenses possible to the advance payments, but we will talk about it in more detail. The second kind of defenses is contractual defenses. So these are the defenses that are in the contract between you and the party. The most common example of such defenses is called force majeure clause or an act of God clause. So I can't perform the contract because God did something, right? So thunder struck or the lightning struck and the building burnt down, or there were natural disasters, the hurricane came, or pandemics occurred, things like that. So these are extraordinary events, very similar to what I said in the frustration of contract, but now that frustration of contract is in fact codified in the specific contracts that you have between you and the non-performing parties. And so these are scenarios which are beyond the control of parties, and they have been codified. Where would you find these clauses? Most common, these clauses, force majeure clauses, will be an insurance contract. If you have an insurance contract for your house or for your car, you read the conditions, terms and conditions, and you will find that there will definitely be a force majeure clause in there. Not common in summer camps, and you won't see, unlikely that you will see it in a summer camp contract. So what are the consequences of, if there is such a clause? The court is going to enforce that contractual provision, and generally what will happen is all parties will be relieved of their obligations and liabilities, or if the liabilities can be postponed, then they will be postponed to a different time, but it depends, right? And then the potential, there's a potential for refund of advance payments or deposits that have been made, and then there's a potential for deduction of related expenses. But whatever the contractual provision states about that occurrence, then the court is going to imply it, because the court is going to impose it, unless there is a violation of some sort of statute, which brings us to our next defense, which is the statutory defense. Now, statutory defenses are defenses. So remember that the legislation, the statute, trumps the common law and contractual defenses. So if there is a statutory provision that applies to your circumstances, then that provision is the one that the courts are going to enforce. Now, with respect to our scenario, there is a statute called Frustrated Contracts Act of Ontario. It's in Ontario, and I understand that other provinces have similar legislation. I've provided the link here. And what does this contract does? It deals with scenarios, it deals with contracts that have been frustrated or are impossible to perform. So what happens in those contracts if court finds that a contract is frustrated or it is impossible to perform? Then section 3 sub 1 and sub 2 require the return of monies that have already been paid by one party to another. So refund, give it back. And there are expenses that could be deducted. So there are two sides of it. Money needs to be paid and expenses can be deducted. Now, section 3 sub 6 also says that the court should enforce, if there is a contractual provision between parties related to the frustration of contract, then court ought to enforce that provision. There's one more example that I'm here to provide, which is a legislation called Air Passenger Protection Regulations. It's in Canada. I've provided the link. And if you look at that legislation, section 17 sub 2 requires the airlines to refund the ticket if the flight is canceled, which is the situation for most people. So the legislation does not say you can give them a voucher and send them away and they can fly in a year's time. If the passenger is willing to accept that, that's fine. But the law requires the airlines to refund full money under section 17 sub 2 of this regulation. So let's sum it up again. The non-performing party may have a contractual common law or legislative or statutory defense. So that is the only option they have, which may enable them to limit their obligations or limit their liabilities depending upon the circumstances. And so now we understand the law. We're going to take this law and we're going to apply this law to STEM camps because we're aware of the circumstances of that case. We'll apply it and then we'll see whether there is any liability, whether there is any refund that the STEM camps are required to pay, which I can tell you yes, the answer is yes. But we will discuss that in more detail in the next lecture. Thank you for watching.